All right, let's get right into this. Come here for a second. I want to show you something. Basically, a new kill switch has been installed at the Social Security Administration. A little bit sweaty because I was outside walking shadow. That essentially allows a person to opt into requesting that their benefits either continue or basically not happen. And this is a kill switch in all true sense of the word, because literally your benefits will be cut off. It is a benefit kill switch for Social Security benefits. There was an emergency message released in the back-end system of the SSA that basically is part of EM-25033. Again, EM-250-33 if you want to go ahead and follow along. It was released on 5/28/25. It was the implementation of Form SSA 792, which is the Statutory Benefit Continuation Election Statement. Let me read through the basic things so you understand exactly what's going on with this and have a better understanding. Retention date 11/27/25. This emergency message informs technicians of the implementation of the new Form SSA 795 Statutory Benefit Continuation Election Statement and provides interim guidance to field office technicians. Background: Statutory Benefit Continuation, known as SBC, allows Title II and Title VI individuals and Title II auxiliaries to continue receiving benefits while they appeal a medical cessation or adverse medical reopening determination. All right, so let me put it in English real quick. In English, when they want to take away your benefits and they notify you that they're going to take away your benefits, what happens is basically you get a short period of time to respond as to whether you want to keep your benefits during the appeal process. So let me read it to you real quick. To elect SBC, which is the statutory benefit continuation, the individual must submit their request in writing within 15 days from the date of the determination notice. You get 10 days plus 5 days mailing notice. Real quick, super duper thank you, Princess Diana, for the $5 donation. Let me go ahead real quick over here and do a little heart. That's awesome. Howdy, I greatly appreciate you, what you do for us. Bless you. Thank you, Diana. Great to see you. I hope you're doing super duper well. She is one of our long-standing, not only members, but viewers in general. So long-time subscriber. So she's pretty much royalty on this channel. So just be nice to Diana. It's very important. So with that said, I want to make this, super straightforward and clear. They have now created basically a form that is part of the kill switch, statutory, you have to do this by this date, requirement. So it's no longer you just send in like an SSA 795, which is a statement to claimant general, hey, I want to continue. It's no longer like that. Now they have an official form that is used to keep your benefits from ending. So let me give you some more information about it. That way you know what's going on. Remember, you get 15 days, 10 days plus 5 days. But that's from the date of the mailing. That's not from when you receive it. I want to real quick, be real direct about that particular detail. That is from the date they mail it. You look at the letter where they're ending your benefits, right? They're going to kill off your benefits, right? You look at that date on that letter and you go 15 days from that, not from when you received it. All right, cool. Effective with the publication of this EM, SBC election statements are collected on the SSA 792 Statutory Benefit Continuation Election Statement. This policy change replaces the use of the SSA 795 Statement of Claimant or Other Person for SBC elections. All right, so let me put that in English real quick. The 795 form, that is like a general statement of claimant, is being replaced by the 792 specific form for SBC continuation of benefits. So one of the things you could use, ... in the future, if you want your benefits to continue and you didn't receive that SSA 792 form, then you could go ahead and use that basically to your advantage going forward. So as a result of that, that's something you want to keep in mind, is that they now have a specific form, and whether you had access to that form or whether you received that form or whether you had noticed that you had to use that form are all things that you have to consider in case you missed the deadline. Cool. The new form, SSA 792, Statutory Benefit Continuation Election Statement, standardizes the collection of an individual's benefit continuation election choices during a disability cessation appeal. The SSA 792 form clearly explains the options available for continued disability benefits and Medicare coverage, and includes a section to complete the good cause statement for late filing, if applicable. Wink, wink. Wink, wink. Late filing, if applicable. If you are late in requesting that your benefits continue because you just realized that your benefits didn't come the next month, it has a good cause built-in statement already for you, which we're going to go through, and then I'm going to help you with what you need to know as to things you need to write in. Because Uncle Walter does good by you. He does very good by you. Let me tell you. You know, it's funny about that. I am now, and this is Shadow. Shadow's demanding snuggles. It's weird. I am the most viewed, the most subscribed to, the most clicked on disability attorney in America. I just saw Atticus found somebody that looks like me, dresses like me, and they're starting to do videos with that person advertising about why they should choose Atticus. And Atticus is basically, it's a law firm that sends you off to other law firms. It's a referral system, right? So when you call them, they mass advertise for disability benefits, and then they send you off to one of their like pre-selected law firms, right? And they called me, and I was like, I don't need, I'm the most viewed and subscribed to and clicked on disability attorney in America. Like, I don't need referrals. I don't do that in the disability world because, you know, for disability law, like, I just don't need the clients. Like, you know, I'm almost always trying to hire more people to process more claims, you know? So basically, you know, what amazed me is that they literally hired somebody that looks like me, same kind of roundish face, you know, same kind of whatever, same kind of age group. And basically, you know, the dress is kind of like with a shirt kind of thing. He's got like a gray shirt on. I have a gray shirt on all the time and stuff like that. So they hired a guy, and he comes off as like extra Italian, you know, but that's not me. I'm a combination of tri-stater and Jewish. So, you know, the bottom line is like, you know, that's just who I am. But what was interesting for me is like they're using this guy to try and get more people to call Atticus, which is fine. That's their business model. That's or whatever. But, you know, I always tell people, if you're going to hire a law firm, you should actually hire the law firm, you know what I mean, that you're going to like hire. You know what I mean? Like, you know, otherwise you're just paying another group a fee, you know, to basically get you to somewhere else. And that's not, you know what I mean, for the sense of disability law, that's not a good thing. Medicare, that's fine. That's how it is. Like, you know what I mean? That's, you know, government comps that fee and all that stuff. But in Social Security disability world, just call the law firms if you want to hire somebody. You don't have to hire me. We're a picky law firm. You know what I mean? Like, if you think you've got a great claim, you know, by all means, give us a call. Sure. But like, you know, we're a picky law firm. These other groups out there, they're getting fed from these referral groups, and then they got to pay a percentage, 10%, 15%, 25%, 5%, whatever, of a fee to that referral group from whatever they make off the claim, which means they can't spend as much on your claim for representation. But anyways, back to this. I just thought it was interesting. They like literally made somebody like do content that looked like me. So, all right. So here's the basic thing that you need to know. Accessing the SSA 792 form, providing individuals with multiple ways that they can obtain the SSA 792 form will help support timely submissions of the form and reduce potential recontact. So the SSA's main thing is, you know, they care if they're going to cut the benefits or not, but the big thing is they don't want to have to call you over and over. Recontact, as they call it, where they have to reach out to you again, is very, very costly because you go on a calendar for somebody and then that person has to reach out again, and it costs a lot of money for that person to try and get a hold of you. The SSA would love a program where you get your benefits and they don't have to interact with you, and it is what it is and everything's fine. If they have to take away your benefits, they want to know right up front with direct contact what's going on. You interact with them and there's no recontact. So, you know, because remember, they got to pay somebody a salary just to call you back. An individual appealing a medical cessation determination who wants benefits continued during their appeal can obtain the SSA 792 in the following ways. Directly from the SSA website, ssa.gov/forms, just type it into Google, SSA 792 PDF, and it'll pop right up. Just pop it right into Google. Through upload documents in the June 2025 release, upload documents can be accessed through an individual's My Social Security account or a link on the ssa.gov website. Again, just Google SSA-792 PDF. It'll pop right up. Or by contacting SSA over the telephone or by visiting an FO in person to request the SSA 792. If you don't have a printer, go there, cool, I got it. But I mean, remember, just literally Google it. It'll pop right up, okay? I've got it right here. We're going to go through it right after this. So if the individual visits the field office in person, obtain the SSA 92 from Inform, which is basically where they have their forms linked. Reminder, to continue benefits, both the SSA 792 and the appeal request must be received within 15 days from the date of the determination notice, unless good cause is found for a late election. If the individual only requests the SSA 792, ensure the individual has the appropriate appeal forms to submit a complete appeal request. Okay, so remember, they want to also collect from you like a 3441 if it's like a medical denial, or like, if it's a 561 or a 632 or whatever. They want to collect all the forms that it might be necessary to go ahead and continue the claim at that time. FO processing instructions. So these are the processing instructions that the SSA bosses are directing the field office to go ahead and do. Upon receipt of a completed SSA 792, process the appeal request and SBC election following standard procedures and place the SSA 792 in the individual's official folder. So they receive it, they process it, and they make a decision whether or not you get to keep your benefits going forward. For fully electronic folders, fax the signed form SSA 792 with the SSA 792 barcode into the section E of the electronic folder, EF. Verify the document is in the EF and shred the paper form. If the folder of record is paper, scan the form into Evidence Portal and place the signed SBC election statement in the section E of the modular disability folder. So in other words, what they're saying to the local field office is, get it into the E folder. Get it into the E folder. And, remember, with their system of the actual Electronic Records Express, in their overall system, there's the A folder, B folder, D folder, E folder, and F folder. And this stuff goes into the E folder, okay? Good cause consideration. There's no C folder. They got rid of that. Good cause consideration. So this is like, if you're wondering if you have benefits and one day they're going to try and remove them, this is where your brain needs to like turn on and start thinking about, hey, if I don't get this form in fast enough, what are my excuses, my reasons as to what should happen next? Okay, here we go. An SBC election is considered late if it is received more than 15 calendar days, 10 days plus 5 days for mailing, from the date of the medical cessation, adverse medical reopening determination, or an unfavorable reconsideration on medical cessation determination. Okay, so from the date of the medical cessation, they're saying you're no longer severe because the medical treatment is saying that you're better now. Adverse medical reopening determination, right? They're reopening the claim to look at it because something doesn't make sense with the medical documentation you had in there. Or an unfavorable reconsideration on medical cessation determination. Let's say if they want to take away your benefits, you keep them, you appeal, you get to the ALJ, or you get to the DDS reconsideration stage, you have an unfavorable, and they're like, hey, we want to pull your benefits. Do you still want to keep them going? Because you'll owe us a lot of this money if you're unable to prove that you're still disabled. The SSA 792 includes Section E, good cause statement, where the individual provides the reasons for their untimely submission. Follow existing procedures for making a good cause determination and documentation requirements. So the local field office is going to decide whether or not your benefits will continue or not. It's not a higher level person. It's a local field office rep is going to decide whether your life is going to suck or basically, be still bad, but, a little bit better. You'll have your benefits, but you'll still be worried about losing them. Direct all program related and technical questions to your office TE or program service center, operations analysis staff, RO support staff, or PSC OA staff may refer questions, concerns, or problems to their central office contacts. So the bottom line is this, like, just to be clear, right? The SSA local field office will receive this new kill switch form, the SSA 792, and decide whether or not they feel that you should receive your benefits if you're beyond the 15 days of allowable. Let's talk now about the specific kill switch that they just put in, the SSA 792. This form is time sensitive. If you want to continue to receive benefits pending the outcome of your request for appeal at the reconsideration or hearing level, we must receive this form no later than 15 calendar days from the date of the notice informing you of our determination ending disability benefits. If you submit this form more than 15 calendar days from the date of the notice informing you of our determination ending disability benefits and ask to continue receiving benefits, please complete Section E, good cause statement. To explain why you are submitting the form late, we will review your reason for submitting the form late and determine if we can accept the late form. If we find you have a good reason, we will continue your benefits. When to complete this form, you must have submitted a request to appeal the determination to end your disability benefits because we determined you or the number holder on whose record you receive benefits are no longer disabled, meaning Social Security SSDI benefits or Social Security Supplemental Security Income benefits. Complete this form if either of the following applies. You want benefits continued during a medical reconsideration or a hearing appeal, or you want to decline continuation benefits during a medical reconsideration or hearing appeal. All right, so we're going to go through the basic definitions because you know what those are. You know how to submit it. All right, let's just go through the sections so you know what they are. So basically, complete each section, blah, 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 blah. Okay, section 1, name, social, all that jazz. You put that stuff in. SSIs, you put in whether or not you want your SSI benefits to continue. If you're a number holder, benefit continuation election, I do not want any of my benefits continued. I want all my benefits continued, including SSI. I want all my benefits continued, including SSI, but I do not want benefits continued for everything else. I want all my benefits continued for myself, including SSI. I want only the following entitled individuals to receive benefits during my appeal. You can specify names. So basically, you outline what benefits you want to continue. Most of you are going to say all of them. You're just going to say all of your benefits, okay? Section D, you outline basically spouse, widow, or child benefit election process. I do not want any benefits continued. I want all my benefits continued, including Medicare. I want only Medicare coverage, but I do not want any benefits payments. I understand that will be billed directly for supplementary medical insurance coverage, yada, yada, yada. Okay, then they have this big section at the very end, section E. Okay, now remember, if these videos help you, please remember to like, subscribe, and if you want to, head over to Google and type in Disability Resolution Law Firm, my finger is a Band-Aid on it, or Disability Resolution Florida, and throw some stars up there. I always love seeing that. All right, let's talk about what they say here, and then I'm literally going to walk you through that, basically, I'm going to walk you through essentially what your options are if you miss your 15-day deadline. I'm going to feed you what you can say to them to try and get it through and have your benefits continue. Section E, good cause statement. Complete this section if you want your benefits continued, and if you are submitting this form more than 15 calendar days from the date on the notice informing you of our determination ending disability benefits. Explain the reason you did not submit the request for benefit continuation within 15 calendar days. If we determine you have good reason for the untimely request, we will accept your election request and continue your benefits. All right, let's talk about this. All right. So I want to go with you essentially the reasons why you would essentially have good cause to go ahead and, pretty much have the right to continue an appeal going forward, even though you missed the federal requirement of 10 days plus 5. So I want to go through some of the basic excuses outlined in CFR 20 CFR section 404.911. So you guys have a better understanding as to what they're specifically looking for. They're looking for homelessness as an excuse. You were sick as an excuse. You were in the hospital during a portion of the appeal period, right? During that 10 days plus 5 days. You were without friends or family or on bad terms with friends or family, and you relied on them to assist you with getting documents to where they needed to go. They are also looking for if there's a potential death or serious illness in your immediate family. Okay. They're also looking for an excuse where basically important documents were never received, or they were destroyed, or they were damaged by fire or other accidental cause. Documents that could have been lost during transport, documents that could have gotten wet due to a flood or a really bad rainstorm or being homeless. Maybe you sent the appeal documents to an online source that misled you, and basically, it didn't go to the proper Social Security website. You sent it to one of those like other advertising things, where you look at Google and Google has like advertise like appeal your disability benefits now, and you clicked on that, and they never got it into the SSA, which happens. That's a real thing. You'll send it to like one of those like online, advertisements at the top of the search page, and it will never get in. It will never make it to the SSA. Animals that destroyed the documents were confiscated and never returned. Those are all very good excuses. Another one is you were trying very hard to find necessary information to support your claim, but did not find the information within the stated time period. So, for example, you didn't know what to do. You were looking, but you couldn't find it. And then ultimately, because of your situation, you just You could get it in. You could have another one, which is you ask for additional information explaining the action or what was going on or how to appeal, or you ask them to send you an SSA 792, or you ask them to send you a form of what you send in, and then they never respond. They never send it to you. That's another good example of why you would have good cause to turn your benefits back on beyond the 15 days. Basically, another one is where the SSA gives you incomplete information or it's incorrect information. Like you call them up and you're like, hey, what do I do? And the SSA person is like, well, you should just wait. You'll probably get another letter, and the next letter will describe something. That would be an example of incorrect information provided by an SSAFO person, like a field office person. Happens a lot. It's okay. Next one, you did not receive notice of determination or decision. The claimant did not have a mailing address, right? So the mail couldn't get to you. Maybe the mail was returned for some whatever reason. I know I mail a lot of stuff, and I've got 2 pieces in my car right now that have to go out that are second attempts. There was nothing wrong with their address. Okay, you sent the request to a different government agency in good faith. Like let's say you sent basically this request off to Health and Human Services, HHS, or maybe the IRS or whatever, and it went to the wrong place, or maybe you sent it to the wrong group. You could have sent it to the hearing office. You could have sent it to the wrong field office, whatever, and they didn't forward it forward. That would be another good cause statement as to why they should continue your benefits. Unusual or unavoidable circumstances, things were like, you don't know how to read, you don't know how to write, basically you were injured, you had brain trauma, something that you were in a car accident. An agency representative gave you confusing or incorrect or incomplete information. We kind of already went over that. And then the other one, of course, is that you didn't understand what you're supposed to do. You just didn't have an understanding as to like how you were supposed to functionally get your benefits turned back on. For example, you didn't speak the native language of the person that was telling you something on the phone with the SSA. You received multiple appeal forms. You didn't know which one to fill out. You have an eyesight issue and the print was too small and you misread it. You have low cognitive ability, a low IQ, so you just couldn't figure it out. You had a non-legal rep. Another one I see a lot is non-legal reps that work for the county or whatever, and they'll be like, yeah, I think you just kind of do this, and they'll be wrong, right? And then basically they incorrectly advise you, and now you don't know what to do, you don't know what to submit. Or it could be a child claim. The child's like on their own, and basically, they don't know what to do, they don't understand it. Or another one that is very common. Another one that is very, very common. Very common is when a child relies on the guidance, on the counsel of a parent. If I could say one thing about Social Security benefits, the most ill-advised and giving poor advice group out of everybody are parents with kids. I have never seen a group give so much bad information to a kid in my entire life. If you are a parent of a child, I'm not saying you have a duty to learn how it actually works, but like start somewhere. You know what I mean? Because all the crap you heard from your friend, your sister, your brother, your uncle, that person that works over there that might have, at some point had something to do with the program, all that stuff you hear isn't necessarily what the law actually is. So there's a lot of like, well, I heard, well, I think, well, da-da-da-da-da. Just start learning. Start Googling. All the stuff on Google there's a lot of amazing stuff on Google. Not all of it's right. Not all of the stuff on ChatGPT is right. I've noticed that. Somebody sent me something like a week ago, and ChatGPT had it completely wrong, but that's okay. It's not all right, but start learning, because as a parent of a child, you guys are famous. I mean, famous for advising people incorrectly about how this stuff actually works. I don't know why. I don't know if you get like a woo, you know what I mean? A good feeling because you feel like you're being helpful or whatever, but like just start reviewing it. All right, now next thing, we're going to go through the section F, required signature. This is where you like sign that you know what you're doing, you accept the terms. So let me read it to you so you understand what it is, and I'll put it into simple English. We cannot continue your benefits unless you complete this section. I understand that if I do not elect for benefits to continue when I request reconsideration, I will not have another chance to elect for benefits to continue. Sorry, I will not have another chance to elect continued benefits again until I get the notice of reconsideration decision on my disability appeal. So in other words, if you don't do this now, then you're going to have to wait, and you don't have good cause, then you're going to have to wait until reconsideration makes their decision. right? Which means you're going to be waiting months and months and months without a check, which is a class 5 no bueno, okay? While my appeal is pending and my benefits are being continued, I agree. You know what's weird? They did different size fonts. Look at that. The font for these 2 paragraphs is bigger than the font for these 3. Oh, come on, SSA. Come on, get it right. Come on now. While my appeal is pending and my benefits are being continued, I agree to report promptly to the Social Security any changes which may affect my right to receive benefits, such as work activity or changes in the status of dependents receiving benefits on my record. So in other words, it's saying, hey, you start working, you start doing this to cover costs, you got to let us know because we're going to use that as evidence to potentially keep you from getting benefits. By signing this form, I attest that I understand if my appeal is unsuccessful, the payments I received during appeal will be considered an overpayment, and I will be asked to pay the money back. I understand that and that's important. If you fill out this form and you lose, you owe a massive overpayment to the U.S. Treasury of the United States, which is like the #1 group you don't want to owe money to. So, like, think about it. Are you really still disabled? A lot of you guys, there's a lot of people out there who become no longer severely impaired because, they've been resting, they haven't been working, their medical condition has gotten better, they no longer have anxiety as bad as they used to, blah, blah, blah. There's a lot of people who get better, but mentally, they define themselves as a disabled person who can't work, even though they could start working. Those individuals, to be fair, are essentially, prime targets for this new Trump administration with the OIG, Office of Inspector General. Like, they are prime targets. So, just keep in mind, if you were found disabled 5 years ago, 10 years ago, 15 years ago, and you have gotten significantly better, that is going to be a prime target unless you're, approaching, 62, 63, 64, then you're so damn close to retirement, they don't want to spend the money looking into it. All right, so by signing this form, I attest that I understand if my appeal is unsuccessful, the payments I receive during appeal will be considered an overpayment, and I will be asked to pay the money back. I understand that I can ask for SSA not to collect the payments received during the appeal by submitting a request for waiver of overpayment recovery form, SSA 632. If SSA approves my request, I will not have to repay these payments. I will not be asked to pay back any Medicare benefits I receive while my appeal is being decided, if applicable. So you win, you're good. You don't owe stuff back. You lose, shit day. Very shitty day. I declare under penalty or perjury that I've examined all the information on this form and any accompanying statements or forms, and it is true and correct. To the best of my knowledge, I understand that anyone who knowingly makes a false statement about a material fact in this information or causes someone else to do so commits a crime and may subject to a fine or imprisonment. So don't fraud the SSA because they're putting more people in jail than they've ever done before. You sign it, put your mark down, put your name down, etc., and get her done. That is the new Social Security kill switch. That is the new Social Security kill switch for benefits. You need to know about it. They don't use the SSA 795 anymore. As of this date, as of 5/28/25, they officially switched to this new kill switch. So if you want to keep your benefits on, use this form, SSA 792. SSA 792. It is crucial. If you do not use this form, you're basically not using the power of a written statement. You can always call them and tell them you want to keep it on, but they still may require you to send it in SSA 792. Please wake up and realize that there's going to be a lot of CDRs in the future. That is the whole point of efficiency and getting rid of fraud at the SSA. There's going to be a lot of CDRs where they're checking to see if you're still severely disabled. If they want to pull and take away your benefits, SSA 792, it looks like this, SSA 792 right there. That is the form you fill out. All right. I will catch you later tonight. Attorney Walter Hnot, Disability Resolution PA. Please remember to like and subscribe. These videos are very helpful to people. Please, it's really important. So anyways, also remember, I'm going to be going live tonight to answer questions for free. I don't know what time, but it's usually like 11-ish, 12-ish at night. Please remember also one thing that I love. Some of you do it, some of you don't. I get it. It is what it is. If you go to Google and type in disability resolution law firm or disability resolution Florida, I always love when people throw stars up there. When I wake up and see those stars, obviously the fives are the best. But when I wake up and see those, they really like get me jazzed to go forward and work. So it's just something. But other than that, I'll go live tonight. I'll answer questions for free. Oh, and then also mini contract below if you need a private session to hire me to go through what's going on with your claim status. All right. So if you got some weird situation or investigators are following you around, or you're figuring out like how to file for disability benefits and leave work, like what your transition is going to be like, give me a call. I'll walk you through it. All right. I'll catch you a little bit later. Have a wonderful day. Attorney Walter Hnot, and we will go from there. Thank you so much. Bye-bye, everybody. Bye-bye.